the measures that should be in place in order to make actors under public-private partnerships accountable. And we know that the actors include the state and then private players. And in this case, in many cases, we do have corporations, for example. Now, public-private partnerships change the dynamics of public accountability by bringing private actors into decision-making and also in the delivery of services, which ordinarily doesn't happen when the state is acting alone. But holding private actors accountable under the current regime, where international human rights law largely has states as the primary duty bearers and where accountability by private actors is largely voluntary, is always going to be a challenge. Therefore, enforcing accountability under PPPs will require careful consideration, innovation, and proper safeguards to ensure that human rights are not compromised, and that both public and private actors are respecting human rights. In that regard, enforceability should be multifaceted, and it should apply at all levels. There has to be mechanisms at the national, regional, and international levels. Now, starting with the national level, there must first of all be strong domestic regulatory frameworks that are justiciable and can enable access to effective remedies in cases of violations. Now, some of these mechanisms can include, for example, ensuring that the rights we are talking about are enshrined under the Constitution and therefore can be justiciable. Here we are talking, for example, about the right to education, equality and non-discrimination, the rights to participation, access to information. All these rights must be enshrined under the Constitution or whatever supreme law that a country has. Secondly, there must be enabling law to assist in the implementation of the rights that are provided for under the Constitution. In the case of Uganda, unfortunately, there is an anomaly that we had our Public-Private Partnership Act only passed recently, about 3 weeks back, and it is still awaiting presidential assent, yet public-private partnerships have always been implemented as such since 2007. Already that is problematic. It should happen the other way around, that the regulatory framework is in place before the implementation begins. But that said, the fact that the law is in place is helpful. The content of the law is another issue altogether that requires detailed discussion that I will not go into currently. But also, aside from the public-private partnership law, there are also other laws that could enhance accountability. One of them is the Education Act, which regulates both public and private actors. The problem with that is around enforcement of the provisions of that act, but at least the act is in place. The other acts that exist include, for example, the Anti-Corruption Act, the Access to Information Act, the Whistleblowers Act that protects people, for example, who may be whistleblowing on issues of corruption. Now, apart from the laws, we also have to have an independent institutional framework for enforcement of what is provided for under the law. In this regard, there has to be existence of independent human rights enforcement mechanisms. The first of those would obviously be the judiciary, or the courts of law, and the functions that they could play include, first of all, adjudicating human rights cases, for example, strategic litigation or public interest litigation cases. They can also preside over criminal cases, but also they can handle civil matters that may be brought against the private actors in situations of PPPs. But then we must note that there are some challenges, especially with the civil cases, because in many cases, private actors will, for example, require security for costs before even the suit starts. And also there is the issue of costs after the suit in case somebody loses. So you find that this will inhibit bringing of cases by, for example, poor people who may fear losing cases and therefore having to bear the burden of costs. So these cases have to be well thought through. But also at the national level, there are quasi-judicial bodies, for example, national human rights institutions, and in the case of Uganda, for example, the Equal Opportunities Commission. There are other ombudsman institutions, for example, like the Inspectorate of Government. These are always useful in terms of accountability, in terms of reducing the potential negative effects that may result from public-private mechanisms. Importantly, and bringing the question of participation into play, is the question of existence of sound social accountability measures that can be used by the ordinary person to make both the government and the private actors accountable under the public-private partnerships. And some of the common mechanisms that exist, also including in the context of Uganda, for example, with relation to education, we have the school management committees. We have mechanisms like social audits by the ordinary people, whereby people are following the money, for example, and ensuring that it's going to where it is supposed to go. But also because private players bring themselves into the public arena, and in many cases they are using public monies, they have to open up themselves to issues. They have to open up themselves, for example, to common standards of assessment, which is not happening now. You find that each private player has their own standards of assessment that they are using, and they administer them themselves. So it is difficult to make comparison, for example, to determine where people are in violation or where they are not performing to expectations. Now, there's also important aspects like respect for access to information laws that is really important for public-private partnerships. Now, stepping aside from the national level, we have the regional and international mechanisms. Now, at the regional and international level, the ideal would be for us to have a legally binding instrument that makes private actors accountable for their actions, even including under public-private partnerships. Now, this is a process. This is an ongoing process, and we don't yet have that in place. So what is happening is still voluntary. The companies are acting in a voluntary manner. But then while we wait for that process to be completed, the international and regional mechanisms must emphasize the state's responsibility to protect. One of the useful tools of doing that is by consolidating the principle of extraterritorial obligations, where mother states have the responsibility of supervising and creating safeguards to ensure that their companies do no harm while abroad. Apart from the ETOs, there is also the use of existing mechanisms, for example, the UN treaty bodies that are provided for under almost all international and regional human rights instruments, And these could be helpful, for example, where they have the state reporting mechanism and the individual complaints mechanisms. Because under the state reporting mechanism, a country is assessed on its implementation of a given treaty, but also on how private actors are operating within the state and how the state is able to protect its citizens from the negative impacts of the private actors. And also at the international level, we've recently, for example, seen the Committee on the Rights of the Child, the Committee on Economic, Social and Cultural Rights, and the CEDAW the Committee on the Elimination of Discrimination Against Women, coming up with concluding observations and recommending to states to put in place mechanisms to be able to better regulate and make private actors accountable, which is useful. Now, treaty bodies can also come up with general comments that are useful to articulating states' obligations under the various rights. Then there's also the element of special mechanisms. These are mostly the UN special rapporteurs and then the working groups that may be set up. Now, the special rapporteurs, the example we have is what we are doing at present. The fact that the UN Special Rapporteur on the Right to Education has come up with an initiative to write a report on specifically PPPs and how actors can be made accountable. It is useful because it guides states that are implementing these PPPs on how to ensure that there is accountability on both sides. Now, finally, I would want to speak briefly about the regional bodies and put more emphasis on them. Regional bodies, I mean like the African Commission on Human and People's Rights, but also sub-regional groupings like the East African Community. These groupings usually bring together countries in the same continent, and usually they are at the same level of development. So the question of comparison is usually easier, for example, when you're comparing Uganda to Kenya. And you find that states are usually more inclined to implement or to listen to the recommendations that are coming from these regional bodies. And when you come to the East African Community, for example, the sub-regional groupings, usually there is also a requirement that once a treaty or a protocol exists at that level, then the countries are supposed to align their national laws to make sure that they are in conformity with what is with what has been said at the sub-regional level by way of a treaty or a protocol. So basically, just to emphasize that it is not going to be easy to have both actors, public and private, accountable under the PPPs, and there has to be a lot of innovation in this regard because there are already some existing mechanisms that can be used. They only need to be implemented, or people have to just innovate around them and ensure that public actors are also accountable.